Fill her up.
You're listening to the Gas Digital Network.
Wow. Okay. The Free State Project. Why do I love the Free State Project? fsp.org/join to find more information. What it's about is a bunch of people committing to move to New Hampshire where you can live the principles of liberty. It's not a political organization. They're a nonprofit charity. They don't endorse political parties. But this is what they've done in New Hampshire. Gun rights. We don't have them in New York. In New Hampshire, you have constitutional carry and castle doctrine, which means, look that up. This is very important. Gun clubs, no knife laws, meaning New Hampshire is the lowest state in America for property crime, lowest homicide rate, third safest state for violent crime. The Free State Project has, if you go to fsp.org/join, you can look at their calendar. It's a social life with people who share your values. There's a ton of legislative victories that they've done thanks to the Free State Project and so many people moving there. No sales tax, excuse me. New Hampshire's Constitution expressly protects citizens' rights to revolution. No helmet law, no seatbelt law. Number one state for cryptocurrency. Number one state for financial literacy. Second lowest unemployment. Music, comedy clubs. Jeez. I'm looking through all these great things about New Hampshire, and it makes me want to move there if I knew how to drive, but I don't. But if you go to fsp.org/join, you can learn more about this amazing legalized home poker, firecrackers legalized needle exchange. They're one step away. So you have expanded castle doctrine. That means no duty to retreat anywhere, anytime. You can lawfully defend your home, property, and family, and anybody. You have a place, a legal right to be. They're one step away from having pocket nukes for your neighbor who's not mowing his lawn. This is amazing. fsp.org/join to find out more.
And there's nothing going on tonight. We could leave the city light, or maybe just get drunk and stay inside.
Good afternoon, Michael Malice here, and let that be your welcome for the next hour. We have here someone I consider, and he's not going to like this, but I'm going to say it anyway, a real American hero, Ron Coleman, who is an attorney. You're representing Gavin McInnes against the SPLC in a major case. The issue right now, everyone talking on social media is social media censorship, tech giant censorship. And what people, I think, don't appreciate is to what extent the SPLC is at the root of much of this, because the pattern goes like this. If you go to any New York Post article, Wired, many of these pieces, they go, okay, according to John Smith, comma, an alt-right sympathizer, comma, right? And there'll be a link. So we have a source. We're not saying it ourselves. And you click on that link, and inevitably it goes to the SPLC. So what's happening is they're outsourcing responsibility for ascribing the most nefarious terms to people. And they've done this to Gavin and have caused enormous consequences for him professionally and personally. And you're like, you know what? This isn't right, and we're going to sue.
That's right. So that's pretty much it. I think we covered it.
What is the SPLC? Southern Poverty Law Center.
Oh, you did the easy answer for me. Southern Poverty Law Center is an organization with a very respectable and arguably heroic past during the civil rights struggles of the previous generation. They took a lot of risks, did a lot of good things, made a lot of changes that have to be made in this country. They were nonetheless very early in their history turned into basically a for-profit business in every meaningful respect. They now are essentially an ideologically, a political hit action group. It's actually rather fascinating because they essentially follow what you and I would almost certainly recognize as being an agenda associated with one political party, which is the Democratic Party. And along with many others like Media Matters, who are working different angles,
Sure.
direct hits on them in order to destroy their careers, to delegitimize them, to put labels on them, as you point out. There's a whole different degree of different types of labels that are used. There's alt-right sympathizer, extremist, hate group. That's really where that's the nuclear one. Hate group, or leader of a hate group,
Or
or
hate
member of a
speech
hate
proponent,
group.
yeah.
Hate speech proponent. And of course, they omit the vast majority of groups, certainly almost all groups that come from a Muslim perspective, if they are what we would otherwise understand as being involved in the hate business. They're not interested in them at the SPLC. What they're also not all that necessarily interested in is facts. They purport to make a factual determination about who's a member of a hate group, who's an extremist, who's a white nationalist, white supremacist rather. But most of the work is done on ideological grounds, not based on some sort of objective standard where you might say, well, here's the kind of conduct that we would expect this individual, like the FBI, for example, says, we're not really interested in labels so much, and we're certainly not interested in group identities. We're interested in what crimes are committed by people, or what people are likely or about to commit crimes. SPLC is not interested in that. They're interested in fundraising, and they're interested in operating, again, as a sort of political ideological hit group.
Yeah, and what they do, from my understanding, is they don't target, let's suppose, per se, the Republican Party or the NRA or organizations. They go very specifically after individuals. I remember I was at the Compound Media Studios. I was doing Gavin's show, and they just came out with this brochure, and they had a list of the alt-right. And to their credit, they distinguished that from what they call the alt-right. And it's basically like a most wanted list. These are the 10 people who are dangerous hate proponents. And basically, it's now you have cover politically, socially, to not deal with them in any way. And they should be isolated and stigmatized.
Well, I would point out that they do focus on certain groups. I mean, one of the greatest harms they did to Gavin was they labeled the Proud Boys a hate group.
Right.
And then smeared him with whatever they decided to smear the Proud Boys with. And in this endeavor, the way that always works is you find the lowest common denominator. The worst thing any guy who ever was a member of a group ever did, and then ascribe it to the entire group. This, of course, never works when you're looking at the left, or you're looking at communists, you're looking at Islamicists. That never cuts that way.
Right.
But on the right, some guy who was kicked out of Proud Boys was in Charlottesville. Therefore, the Proud Boys are a hate group that participated in the March at Charlottesville, and so is Gavin.
Yeah, because the sentence is written now, Gavin, comma, who heads a group that participated in Charlottesville, comma. And just that simply, all these associations are made in the reader's mind.
And at this point, there's someone has recently made some very good points about the limited, the loaded meaning of the term dog whistle. That's become rather meaningless as well. But these are charged terms. They're signals that are sent to journalists and other members of the left-wing establishment to hit. But far more insidious than that. It would be one thing if they were just publishing an opinion ad, or if they were just even publishing what they assert to be fact. But they have also begun an initiative called Change the Terms, where they have a website, but a lot of what's really going on is behind the scenes. They are partnering with various left-wing activist organizations and getting platforms, both social media platforms, publishing platforms that aren't even necessarily what we would call social media, but just ISPs.
Sure.
And of course, funding payment systems, payment platforms,
Like PayPal and Stripe.
and selling them on this idea that not only should you deny your services to people who are designated on any of these bad boy, lists, but in other words, not only should you deny the services to them by virtue of what they do with your service, but we're going to act as a judge with respect, a collective judge, with respect to their entire conduct in life, on or off your platform, on or whether or not they're raising funds for the activity we object to or not, will determine whether their lives are being sufficiently virtuous, and if not, we urge you to change the terms of your user agreement if they don't already give you essentially complete freedom to do whatever the heck you want.
Right.
To deplatform or defund someone that, regardless of the connection between your service and what they're doing.
Yeah, there's something very, and the thing that's interesting here is there's this claim that Gavin specifically is a white supremacist, right? Even though his wife is Native American, his children are mixed race. But the thing is, as I'm sure you've seen, when you point this out, this is of no relevance.
No facts are of relevance, except the facts that are selected and burnished to just the right shine to make the point that they want to make.
So what exactly are you suing them for? What are the charges?
There are
the correct
several
term.
claims. One is a defamation claim. And some people on the internet are under the impression that the entirety of the defamation claim is premised on the argument that the SPLC is designating someone a hate group. We maintain that that is a false statement of purported fact. So their response to that is, well, really, that's just SPLC's opinion. Footnote, I've never seen them suggest that it's their opinion. I think they regard it as a fact. But the fact is, it's almost impossible to take that position if you've read the complaint, which actually details an immense number of other false statements of purported facts about Gavin or about the Proud Boys, which are ascribed to Gavin. And that brings me to the second claim, which is a claim for what's called false light invasion of privacy, which basically is an attenuated form of defamation that says, even if you don't have actual malice, even if you didn't defame the person as defined under the law, you've nonetheless moved the tables and chairs around in a way that a person looking at the way you have described someone would be almost certain to get a damaging false impression of what they're about. And that's a very powerful claim in this context. There's also a claim for tortious interference with prospective economic advantage. Gavin has been deprived of most platforms, which was how he made a living on social media. He has been deprived of virtually all payment systems. And he's suffered other damages, which we will obviously go into a trial, but he's been, this is the case. One of the things that people talk about defamation frequently on the internet, they throw it around a lot. And one of the first questions I ask when someone calls me or these days DMs me about a defamation case is, okay, this really annoys you, but how exactly have you been harmed?
There have to be concrete damages, correct?
It's pretty concrete. And the last thing you want to do is try to say, emotional distress. That's the worst. You never want to go there because now your entire mental life is part of the case. And who among us is really prepared to put that into, to play that way? There's also a little bit esoteric claim under New York employment law, which it's not worth going into here, but we think there's something to it.
Let's play devil's advocate. He's a public figure. He's provocative in his comments. Therefore, we can call him whatever we want. If it's good for the goose, it's good for the gander.
Well, if that's true, then there is no law of defamation anymore in the United States, and then we should just acknowledge that. Right now, every state, even in New York State, even California, even New Jersey, where I live and where I mostly practice, have defamation laws. So although the Supreme Court has made it almost impossible to succeed in a defamation claim involving a public figure. The law is not that there is no defamation of a public figure. And most of my career, in fact, I'm hard-pressed to think if I can remember a time when I've actually ever filed a defamation claim as a plaintiff. I tend to defend them or prevent them from happening by reminding plaintiffs that they've got to be nuts if they think they've got a claim.
Right.
This is the case where there's a real claim, where there's real damage and there is actual malice. You should pardon the expression. And that's an easy one.
Okay. Well, how about this? There's been clips of him on Joe Rogan, and he had the Proud Boys who said they were going to get involved with Antifa. So therefore, he is someone who's advocating violence. Therefore, it's a hate group. That's the logic, right?
Okay, so that's an argument, and I imagine that it'll be made. I will tell you that advocating violence in the free speech context, chances are that a court considering that formulation in a defamation context would not veer very far from the free speech context. Advocating violence is a much more immediate kind of thing than merely saying, I would listen. There's a tweet on Twitter that has been up for well over a month now, involving a particularly obnoxious individual who said regarding one of the Covington boys, "Have you ever seen a more punchable face?"
Yeah.
That's he's advocating violence. That tweet's still up.
Why don't you want to mention his name? I know who you're referring to.
I'm not looking for no trouble. Feel free to mention his name.
Reza Aslan.
Yes. I mean, he's, it's obnoxious.
It's meta.
He's a hateful person.
Yes. He also said he hopes Todd Aiken gets raped.
So now that's a rhetorical point, and that's
Sure.
good for me to, on social media and on your show to make that point. And therefore, when someone says what's good for the goose is good for the gander, obviously it's not even remotely good for the gander. That's not necessarily a point that I can raise as against the SPLC, except with respect to when they say we identify hate groups, I can say, no, you don't. I can identify many people and many groups that you don't care about at all who advocate violence based on ideological or racial or ethnic or religious grounds. You don't care about those at all, just as Twitter doesn't really have rules that govern who gets taken down.
That's a very interesting legal point, because now you're saying, well, if you're claiming that you're actually caring about hate, why are you ignoring these specific other people? Therefore, legally, you have some other agenda than fighting against hate, which kind of feeds into the idea that this is done intentionally and is not being done objectively.
That is a very cogent understanding of my argument.
I did go to yeshiva. Wow, I never thought of it that way, and that's really important.
Yes, it is.
Because if they're going to claim, are they 501c3?
Yes.
So that, which is a not-for-profit. So if they're going to claim, hey, we're providing a public service, we're kind of blind, justice blind, we're putting forth, these are hate groups, we're warning about hate groups, and you're specifically ignoring groups and individuals who are saying much more and much more divisive and much more violent things, clearly you're being, I don't know if it's fraudulent in the legal sense, but certainly dishonest in some sense.
Well, let's just say, without digging any deeper because of the pendency of litigation, that you're onto something that, I don't think that in and of itself would invalidate their 501c3 status. Sure. I'm not with the IRS. I think everyone understands that the IRS doesn't seem to apply this non-political criteria that we, by reading the statute, would think the 501c3 should apply to, except the Tea Party, of course.
Sure.
But that's part of what's in play, and it does go significantly to the question of what their motivation was, and because actual malice is a component for a public figure, it's something we'll be talking about.
So, talking to you now, and talking a little bit before the show, it seems like this is a case that really means a lot to you, right? What is your favorite thing about being a lawyer?
Well, coming from a Jewish background as you do, I wanted to work in a field where there were no Jews. It was too much already.
I don't blame you.
Too much already.
I don't blame you, brother.
I go home.
Those accents. And
legal
always
profession.
the rubbing the hands.
It was either accounting or so yeah.
What? No medical school.
I'm not good at memorizing.
You argued before the Supreme Court, and
Actually, I appeared before the Supreme Court. I didn't argue. I had a partner
Okay.
at the time who was a First Amendment guy, and I was the trademark guy. Even though I'm a First Amendment piker, a trademark pro. And our conclusion as we went from the federal circuit, where I had argued in front of 12 judges sitting on bank, was that at the Supreme Court, they would probably be more interested on the First Amendment side than on the trademark side. So we handed it off to my partner, John Connell, who did say that he did an able job. He won 8-0. So,
but what's it like as an attorney sitting in front of the Supreme Court? Is it intimidating?
I'm not intimidated
Okay.
by much, but it was a feeling of a great satisfaction, because if you've been practicing law as I have for coming up on 30 years, you know, if you're in front of the Supreme Court, that now you have done something that very few other lawyers get to do. And if you're a litigator, as I am, you know that you've if I had to retire that day, I'm glad I didn't, but.
And no one could ever take that away from you.
That's right.
Yeah, like when my first book hit the New York Times bestseller list, it was just like my editor said, "You will always be
a New York Times bestselling author."
And you can and that's something that's rare. It's not that rare. There's thousands, but it's still an indisputable credential. So,
yeah.
Tell me about that case. This was the Slants case,
right? The Slants is a rock group in Portland. They're a rock group in Portland. I don't know how many of them live in Portland right now. The leader of the group, Simon Tam, does not live in Portland now, but they wanted to register the name of their group. They're Asian Americans. The name of the group is the Slants. And
where did they get that name from?
They got that name from an obscure slur used to describe Asians. One that growing up on the streets of Brooklyn I never heard. And in fact, when I was interviewed by an Asian journalist, she said, "Did you ever hear anyone say that? I never heard it." But nonetheless, it's in the dictionary of like sheeny.
I was just going to say, like, Tree Grows in Brooklyn. I was reading Tree Grows in Brooklyn, and they called the Jews sheenies. I'm like, is this bad? Is this like a term of endearment?
Right, exactly, right. Well, in fact, I'd written about this before. I had been approached by Hebe magazine to help them get a second registration. They had already gotten registration, and they wanted to add new goods and services, and they had been rejected under Section 2A of the Lanham Act, the trademark law, which says, "Thou shalt not register a trademark if it hurts somebody's feelings," basically.
Okay.
Not defamatory, but disparaging.
Okay.
And we talked about that. They ended up using someone else. It went nowhere because the courts weren't ready, or at least that wasn't the case. But I knew there was a problem because they had gotten it in the 90s. Why couldn't they get it again, get a new registration? It was the same premise. And in fact, the reason it came to me was that I had been writing on my blog, the Likelihood of Confusion blog, where I write about trademark law, copyright law, and free speech. I had written about the Redskins case. And in fact, my view on the Redskins case, unlike you, I'm a cultural conservative. So my initial view on the Redskins case had been, listen, not every nasty thing necessarily has to be registered by the government. I mean, Let's have civility. Let's feel comfortable with how our government represents us. And when I began to understand what marks were being allowed registration, what marks were not, I saw that there was a political tack to it. And it did seem strange that Jewish guys who want to call their magazine Hebe, or Asian guys who want to call their this is what's called reappropriation.
Yeah.
If they wanted to do that, why should the PTO tell them they can't?
Yeah, I'm thinking specifically of a Hebe magazine photo shoot with Roseanne, where she's dressed as Hitler and was baking Jewish cookies shaped like Jews in the oven, right? And it's like, it's very different when it's Roseanne.
Yeah, I mean,
and
that's
a comedian.
And frankly, I'm never going to endorse that. I think that's in terrible taste, but they have their right as Americans to do it.
Not enough sugar.
It's bad.
Terrible taste.
Terrible. But nonetheless, it's their call. It should be their call. And a lot of people in the trademark law world were bothered that if this goes the way you want it to go, Ron, we're going to have all these registrations for N-word toothpaste and N-word shoes. And
They had that. They had Darky toothpaste.
They did
It
at
became
one time.
Darlie.
The world didn't come to an end then,
Yeah.
has not come to an end since then. Ultimately, the Supreme Court agreed with us and said, when the government provides a service, it can't choose viewpoints.
Wait a minute. Does the rap band NWA not have a trademark in their name?
They do, but it's just for NWA. But
But
that was one of the points that was made
okay.
in the briefing, which was that everyone knows what the N in NWA
Yeah.
is. And in fact, I wrote a blog post using the N word over and over again and saying, who are we kidding? This entire policy, which they're suddenly paying attention to now, which they weren't paying attention to for so many years, is because everyone's terrified that the N word is going to be registered as a trademark, and that's this magic, powerful word that can melt buildings and walls and bridges, and the world will come to, And at the end of the day, we had to conclude that we'll cross that bridge when we come to it. But the First Amendment is not what it was because of what the courts have done since 1948 when the Lanham Act was passed, and under current law, the Supreme Court had no trouble concluding that we were right.
Supreme Court is very picky about which cases it hears, right? Famously.
Certainly.
So how did you find out they were taking your case, and how did you react? Because when I found out about the bestseller list, I literally started jumping up and down.
Well, I knew it would take our case when the first panel when we appealed from the agency court to the federal court, the Court of Appeals for the Federal Circuit in Washington. We appeared before 3 judges, and they upheld the PTO, the Patent and Trademark Office. But there was something very unusual in the decision, which was usually you have majority opinion, and then if there might be a dissent or there might be a concurrence. But here the judge who actually wrote the majority opinion, who said, listen, under existing law, there's no First Amendment right to a trademark registration. Can't help you, Mr. Coleman. Can't help you, Mr. Tam. But there was something called additional thoughts, and Judge Moore of the Federal Circuit said, really, we should revisit this issue en banc, all 12 judges of the circuit. That's when I knew we were going to the Supreme Court. Because the only reason she wrote that was because obviously she was confident that the court would hear it en banc. And in fact, before we even had a chance to ask, basically over the next weekend, they voted to hear it en banc. And then we argued it en banc.
What's en banc?
En banc means instead of a 3-judge panel, which is chosen from all the judges that are a member of that circuit court, every single judge, and it was a little bit, I would never want to call judges clowns, God forbid. I'm still in practice, and they're not clowns. But it was a little bit like when 12 judges come out for the 2 sides.
Yeah.
It's like the clown car in the circus. I mean, they just keep coming and coming. And boy, that was a lot of fun, arguing in front of 12 judges at the same time.
Well, especially you won 12. Was it 12-0 you won on that one?
Oh no! Depending on how you counted, it was like 10-3 or 11 or 10, 11-3 or 10-4 because there were a couple of.
But it wasn't close.
It
so
wasn't
you knew
that-
you had. Did you know you had the winning argument coming in?
Yes, I did, and
Okay.
the reason I did was because again, Judge Moore had really signaled that she thought that this was the moment. My personal opinion was that the Federal Circuit thought this was a case that would be a better test for this issue than the Redskins case, which was moving on a different track in the Fourth Circuit. And certainly after we won on the en banc opinion, which reversed the earlier law, we knew the PTO would appeal. And when a government agency appeals and where a statute has been ruled unconstitutional, usually the Supreme Court's going to be interested.
Okay, yeah. So, but how did you specifically get the did you get a letter in the mail, an email?
Well, I remember a couple of distinct moments. One was when we won. While I was preparing the beginning the process of preparing the request to have the question considered en banc, I got an email from the Federal Circuit. Ping, why is they're done with me?
Yeah.
Well, we took a vote ourselves over the weekend, and you're going. So I remember that. And I don't remember when the Supreme Court granted cert, but that wasn't the exciting part because we knew they were going to grant cert. But I will tell you what I remember when the decision came down. I was in a shoe repair shop on Main Avenue in Passaic, and waiting for the guy to give me back my new soles. And ping, so being an obsessive, mobile user, I looked at it, and we were already on tenterhooks. It was about time, And there's that notice from the Supreme Court. And I said, Jesus, how am I going to be the first to get this out? And then all of a sudden, Randazza tweets, "Hail Coleman and McMullen," one of my partners. Section 2A is dead, and it was wild. It was wild.
What's your favorite thing about being a lawyer? That sounds so rewarding.
The shoes. You can get away with these shoes. It's a little bit harder now with the X-ray machines when you go into court. These? You can, but unless you want to actually wear them to work when you get home or in your
boots,
office.
baby.
I dress like a 1950s banker, and I enjoy that.
So let's go back to the SPLC. Gavin is not unique here. Is that going to be part?
That's the first time anyone ever said that about Gavin. We found it here where he's not unique.
But I mean, they had to settle with Ayan. I don't know how to pronounce it.
Ayan
Hirsan Ali, right? And they called her an Islamophobe or an anti-Islamic extremist, and she is.
I don't know that they settled with her. I think that they removed the comment about her. I think they backed down from that. What's unusual about Gavin is that they love him. His face is all over their website.
It's always these specific pictures where he's looking angry, even though he's.
How angry is it? I mean, look, he's funny looking. I mean, it's part of his shtick. The horn-rimmed glasses with the hipster beard and the tats and the short-sleeve shirt with the tie. Like, it's his look.
It's falling down. That's what he's doing for the movie.
Right.
Yeah. Did you see the video where he shaved his beard?
No. I don't have time to catch up on the works of Gavin McInnes, nor do I have the stomach, frankly, because this is not safe for family time stuff,
He had to shave it because he did the profile view, and he's like, "I look like Beaker from the Muppets. I have no chin, you fuckers. This is what you made me do."
Well, I understand that very well. I mean, to me, it was obvious, certainly once I put on weight, that the beard was the move for me, especially as an Orthodox Jew. And my wife said, I married a clean-shaven guy.
Yeah.
And that's not happening. So,
this week's episode brought to you by Flyby. You guys saw the arduous march, how horrible it was. I wasn't doing a great job the next day. If you go to flyby.co and use promo code YM15, you get 15% off. What's Flyby? It helps you process those alcohol-induced toxins. These are the actual toxins. Not the kind of things you hear about in the Whole Foods place. When you get drunk, you actually have toxins in your body. It supports healthy liver function, replenishes lost vitamins and minerals. What that means? No hangover. If you go to flyby.co, promo code YM15, you get 15% off. Here's some of the ingredients. Milk thistle helps prevent liver damage. Bodybuilders use this also. Prickly pear counters alcohol inflammation in your liver. NAC. I used this after the arduous march. It increases, something I can't even pronounce, but it helps the liver process those toxins that are in your body. And DHM, which boosts the liver ability to process alcohol. Plus, it's got vitamins, got amino acids. You have a good night, you should have a good morning. Use promo code YW15 to save 15% off. Promo code YW15.
Gavin is really special to them because he doesn't look like the guy next door.
Right.
There are action shots of Gavin, right? There are situations where he is surrounded by the Proud Boys, the menacing, horrible, terrible Proud Boys, and they obviously have calculated that the SEO generated by his name and his picture is really important to their fundraising efforts, and it's amazing how much material there was to work with on their website when looking at how what they said about Gavin. So he is unique in that respect, and he's also unique in another respect. I mean, let's not kid ourselves. There are a lot of really awful, disgusting people who are identified as extremists, neo-Nazis, and members of hate groups on the SPLC website. These are really bad guys. Many of them aren't nearly as bad as either the SPLC or they themselves like to think they are, but they're bad. Gavin is actually not. Why did I end up working on Gavin's case? Because I'd been on his show like 4 or 5 times before then. I knew him. I knew he wasn't an anti-Semite. I knew he wasn't a racist. I knew he wasn't a white extremist. I knew that he was an envelope-pushing humorist, and that there was, if you would have asked me, is there stuff that you can hang your hat on that people are going to say he's a bad guy? Of course. That was considered to be something edgy and cool. It's Mr. Vice Media, It seemed like a good idea at the time. No one really figured that what's happening today in terms of the hard censorship and the systematic method that's used to silence people on the internet would become so. I mean, the Carlson Tucker events of the last couple of days are an incredible development where he has pushed back.
Oh, yeah.
Because you mentioned earlier that Gavin, head of the Proud Boys, he resigned from the Proud Boys in an attempt to mollify the Wolf Pack. And Tucker, who is not Gavin, he has many advantages over Gavin.
Sure.
In this respect, he said, "Bring it on. Bring it on. Tune in. See what I actually have to say."
Well, I think one of the things I tweeted out, one big difference between Tucker and Gavin is, first of all, what's happening with Tucker is very transparent. Right, and Tucker's a lot less controversial than Gavin, and there's no even pretense. I think that there is a pretense that I heard these clips and now I'm against Tucker Carlson. It's like there's not one single person who wants Tucker fired now who didn't want him fired last week.
And right, so there are those differences, but as you point out, the transparency in the Tucker situation merely provides for us a schematic diagram of what still went on in the Gavin situation, just that it is obscured by his ability to generate genuine controversy and genuine, questionable taste type stuff, and it worked.
Is it of legal significance that they can say all these things about him, and now because he's been deplatformed, he is not in a position to respond?
Well, that is an argument we make in the complaint, which is that this is, as I put it when in a blog post, this is not your father's defamation. Defamation is usually we say in response to defamation, listen, answer back. Someone says that that you trip old ladies at the crossing crosswalk. So demonstrate. Of course, proving a negative is difficult, but prove why they're wrong, or demonstrate that that they can't prove why you're right. That's not always really an effective defense because, again, it is hard to prove a negative.
Sure.
Nonetheless, that's the constitutional standard. But when you deplatform someone and you deprive them of the ability to answer critics, and there's no government censorship involved, so there's no obvious free speech or no obvious First Amendment issue.
Right.
But you have censorship taking place at the behest of either corporations or activist groups or, in some cases, foreign governments that have influence over either the corporations or the activist groups or both. That's something we have to really worry about. Is there a legal remedy for it? I'm searching for one. I think we might have found in Gavin's case. I mean, they couldn't be much more upfront about the fact that they made an effort to deprive someone of his livelihood and succeeded. So, generally speaking, in commercial conduct, that is a tort. That's tortious interference with prospective economic advantage. There are also defamation claims, blah, blah, blah. I went through that already. That might be the answer. It might be we need some other answer that could pass constitutional muster. And I've written, when I say written, I mean I've tweeted lightly about the topic a little bit. I've discussed it with some people that you and I know together who are in the activist community. And we might have some ideas along those lines. And
just to let people know, people can contribute to Gavin's defense at defendgavin.com.
Defendgavin.com, that's the place to do it.
You're not cheap, but you're worth every penny, I'm sure. So, I mean, what is his, if you can speak on this, I mean, I've talked to him, and he's texted me a few times about this. When you're, I'm sure this is of legal relevance too, when your wife is involved, and your kids are involved, and your home life in your hometown, people are treating you in a certain way, that also has to be of legal relevance.
Well, that's actually a harder question to answer, and you will have observed that those facts have been mentioned in the complaint, and they wouldn't be in the complaint if there were not some legal relevance to it. We're not claiming damages based on, again, mental anguish.
Okay.
But they are relevant because they go to, let's just say, other aspects of the claims. Yes, there are some legal relevance, and they certainly are of relevance with respect to the public debate. what are you doing to a person? Is there really no responsibility in this atmosphere of personal destruction for ideological purposes? And one of the things that really galls me about this is that, it's obvious that they identify people who are effective.
Yeah.
Gavin is an acquired taste. He was not everyone. One of the arguments they have an entire blog post festooned with Nazi colors, where they say Gavin McInnes is the entryway drug to the alt-right. In other words, Gavin McInnes is the least offensive guy we could think of. But we're going to show you how some wahoos said, I first started listening to Gavin, and it wasn't, 3 months later I was listening to old, tapes of, I was reading Der Stürmer in the original. That is, but it's this incredibly effective way of really slamming someone, because Gavin is not the gateway drug to anything. But what he was a very insightful and effective guy.
Yeah.
Who said things that most people have the good taste not to say. It doesn't make them not true.
I have a chapter in Gavin, my forthcoming book, and one of the things that just shows how some things are just being absurd about him, the New York Times had to issue a correction, which was completely insane, where they're like, well, while we said the Proud Boys were like a whites-only group, in fact, they're quite diverse, but whites happen to make up a majority of their members. I'm like, these are two very different concepts, people.
Right, since the whites make up the majority of the members of the people who live in this country.
Yeah, right.
The fact is, though, the Times, if you look at the comments on their website, they got killed by their, regular readers, and for being relatively reasonable and balanced in their treatment of Gavin.
Wow.
When mainstream press, and there are shining moments that we can't take for granted, when serious journalism is being done by the legacy press, which has squandered its legacy so profoundly over the last few years. And they try to give an honest shake to people, and they get killed. They get killed by you might call their base. And the base is meaningful because they're the ones who are supporting,
sure,
revenue-wise, those endeavors now. So,
and the brand.
All they are is brands.
Yeah.
The New York Times, notwithstanding the fact that they have a huge skyscraper across the street from the Port Authority, is not inherently any more credible than any number of friends of ours, including yourself, who do their own research, write things, tweet them, in other words, publish them. There was a time when mainstream journalist organs could say, well, we've got layers and layers of editors. We see that was always true, but it's no longer meaningful. Both on the print editions of, for example, New York, the New Yorker, which was I think the subject of that original quote.
Yeah.
They've rolled out stuff that's preposterously falsifiable. But also you have these echo chambers built around reporters who are media personalities and who tweet using the name of their of the papers or networks they write for, with no editorial oversight whatsoever. Right. And then the echo chambers reinforced their biases and in a way that is entirely unique to the journalistic enterprise. So those guys are absolutely no more credible than Mike Cernovich. It's not even a close. If anything, Mike is far more accountable than any number of the Times or CNN people, including some of them who've blocked me, because they don't want to hear tough questions.
Yeah. So let's pretend we're not talking about this case specifically, right? Let's talk about discovery in general. What happens if I'm a 501c3 and I've got all sorts of shady stuff going on behind the scenes and I don't want you to see it? Can't I just shred the papers?
You can. But if you do, you could be in a world of trouble. In the 21st century, it's very, very hard to hide documents because everything is in digital form.
Okay.
Every email has a companion email or more, either on a server, on a backup server, on the recipient's ends, on the CC recipient, on the BCC recipient. I mean, when I started out in the profession doing document review at a major metropolitan law firm on behalf of a major oil company, we were literally going through documents, and photocopying was, was a thing, and you'd go and you'd say, well, is this copy different from that copy? Well, this one has marginal notes. Now the digital revolution has changed everything.
Sure.
It's really hard. Look, everyone knows what Hillary Clinton did with her emails. She's exempt from punishment from it because of the way politics and law enforcement works in this country. It's a very unfortunate fact. A lot of that stuff has happened in civil litigation too, and a lot of that exemption seems to apply as well. But judges do from time to time latch onto this kind of thing, and let's put it this way. If I were involved in a case like that, that would not be my concern.
Okay.
Lawyers, especially lawyers, don't want their clients doing that. It makes their jobs a lot harder.
Every industry I've worked in is remarkably small and incestuous, right? Are you familiar with the SPLC's attorneys? Are you friendly terms with them?
I'm not.
Okay.
My local Alabama is outside my normal. I mean, I know a lot of the guys in California. I know I've litigated a lot in Florida. New York and New Jersey is where I do most of my work. But my local counsel, talk about a small, cozy bar. So Ron Coleman, who is a little bit of a social media personality himself, who's our local counsel, he knows the SPLC's lawyer down there. And I'm evidently a formidable guy.
Okay.
With a formidable mustache.
Okay, but he's a respectable attorney.
From every indication.
Okay.
Yeah.
No, because
There's no reason SPLC wouldn't use a respectable attorney.
well, no, I mean sometimes people hire like someone who's just basically like
People, yes, but
not organizations.
Organizations worth $500 million. That would be a really rash move, especially when the organization's staff is made up almost entirely of lawyers. I mean,
Right.
they should know what they're doing in that respect.
What was their reaction when you did you give them warning that you were going to sue?
Not really, no. Well, we didn't give them warning. We did give them a courtesy copy of the complaint when they requested it from us. I will tell you what the funny thing about the reaction. They wasted no time coming out with a press release saying that it was meritless, that they were going to defend against it vigorously, and the various pockets of the internet law firm rolled out their analyses of why it was meritless within 24 to 36 hours, if not less. For some reason, however, SPLC then requested that we give them 2 months to respond to it. So it was obviously meritless, but the actual way of figuring out how it was meritless so that they could convince a judge to dismiss it, presumably, seems to be, to be clear, 2 months, usually you get 21 days. They got 60 days, which we agreed to. So, there's the spin, and then there's the actual job of, as they said to the judge when they asked for the time, we didn't consent to it immediately, but we consented to it after they filed their papers, and they said, "Well, this is really long and it's complicated." It's really long and complicated, yeah. So you have to,
How much are you asking for in damages? Is that a number that's thrown out now?
No, it's not a number. Well, some people do that. In New Jersey, where I primarily practice, there's a rule prohibiting lawyers from announcing a number they're suing for.
Okay.
Unless it's a promissory note, like
Okay.
it's a $100,000 promissory note. I don't think Alabama has a rule like that, but it's my sensibility as a lawyer. Whenever I hear, "Oh, he sued them for $150 million," that's just a number that somebody put in.
It's like, how much do you want for your house? $1 billion. That's nice.
I'll bet you $10 billion that I can get $1 billion.
Yeah.
That's nonsense to me. So I'm actually comfortable saying, listen, we'll prove what the damages are at trial. We don't even know them. And that's I think the premise of this New Jersey rule is, how do you know?
Right.
I don't know it. I need to do third party discovery. I need to discovery from them. I need to get an expert on lost profits, on damages. So,
what do you think of this whole?
but I do think it'll be in the range of a 10 to 1 billion. Yeah.
What do you think of this whole Covington lawsuit? I'm sure you've read the complaint.
I haven't read the complaint.
Oh, okay.
I will tell you that I'm surprised that it's. I understand the value of it. I don't. It's a case I would never have taken.
Oh, okay.
I think that what was done to the young people was disgusting. It's done to people on the internet every day. Going back to my point at the beginning of our discussion, proving concrete, non-speculative damages in a defamation case is extremely difficult. And when you have young people, we can sit here and say, oh, it's going to be hard to get into college and they're going to, and no one's going to want to be their friends on Instagram. And yeah.
Yeah, theoretical damages as opposed to this person was fired from these places and whatever.
Speculative damages are very hard. And I think someone was recently quoted as saying, and somebody was on top of them saying, someone had mentioned, you can't get a defamation claim against kids. And someone, I believe, misunderstood that as saying they don't have a right to a reputation. I don't think that was the point. The point is, unless that kid is a member of, a rock group or something, a performer, an artist, most reputations of children are not really actionable. In fact, I can't think of a better way if I were the parent of a child to make sure that my child's name is repeated over and over again in connection with these events than to have him involved in litigation. That doesn't mean there isn't a valid basis for making the choice to do it or for filing the claim. Haven't read the complaint.
Heshy Socks. I love Heshy Socks. If you go to heshysocks.com, HESHI socks.com, use promo code WELCOME30, you get 30% off. Why do I like them so much? Why do I have them as my house socks? Because they're pillows for your feet. They're cushioned in the footbed, they're cushioned in the heel, they're cushioned in the toe. That means they're what? Super comfortable. They've got arch support in the center of the foot. Now, they're also made with high-end Pima cotton, which are highly breathable and absorbent if your feet sweat, and they're also antimicrobial. So it kills the bacteria and keeps the feet from stinking. They're getting you laid. Maybe they should try to get me laid. If you go to HESHIsocks.com and use promo code WELCOME30, you get 30% off, and they're not expensive to begin with. You've got the dress shoes, you got the sneakers. They've got all the socks you want. Nothing makes a suit. You've got to wear a boring business suit. If you have a nice pair of socks that peek out when you're sitting down, you're going to be so cool in the office, and they're going to be like, hey, where'd you get those socks? And you're going to be like, I'm not telling you, you're not stealing my look. But I'm telling you, my dear readers, that if you go to heshysocks.com, HESHIsocks.com, and use promo code WELCOME30, you'll be telling me you're welcome. One of the few people who has me blocked on Twitter, besides a lot of the Nazis, is Pope Hat. And I think I know why. I'm not sure why. I like his work a lot. What do you think of his thought process?
Well, I worked a lot with Ken White. We worked on cases together in the Ninth Circuit. We have also he helped us out, helped me out a lot on a case in Maryland. We used to be very friendly. He stopped following me.
Oh, unfollowed.
Unfollowed me when the Trump stuff became intolerable to him.
He's got TDS.
Maybe he does. He's a very smart guy. We have a lot of friends in common. When I filed the Gavin complaint, he really got disgusted. And then blocked me, actually.
Oh, we're both blocked.
Yeah,
okay.
Blocked. So what do I think of his thought process? I think that he's a very talented and insightful guy, and that we disagree on a number of things.
I can't imagine blocking someone who I've worked with and had a cordial relationship with.
Okay, but he's different from you.
No, I'm sure that's fair. I'm just saying that, especially, I have a lot of friends who I don't agree with on Twitter. I have very few friends I do agree with on Twitter. And especially if it's someone who's a professional colleague. I have a lot of hardcore lefties I follow on Twitter.
Well,
I want to know what they're saying.
Well,
and a lot of conservatives I follow.
I'll go beyond that. I mean, he called me out in a Facebook post.
Oh.
And tagged me so I couldn't ignore it. And said that I was despicable.
Oh, Jesus.
Professionally and personally despicable.
Wow.
So that just tells me that...
That wasn't hurtful?
No.
A former friend?
That
would hurt my feelings.
No, it didn't hurt my... I guess maybe it hurt. I saw that Ken had gone off... Listen, remember what I described before about what happens to journalists? They get surrounded by an echo chamber, and then their thinking stops evolving. That might have happened to Ken. He's got a gigantic following. He's such a good writer, and he's so entertaining and so thoughtful and insightful that he's got lots and lots of fans. He doesn't want to engage with me. It was unfortunate that he felt the need to attack me personally, but I wish that were in the top 10 disappointments of interpersonal relationships in my life. It's not.
Okay, enough of the bad stuff. What's your favorite thing about being a lawyer?
I really am especially at this point in my career, where I'm no longer doing document review for oil companies. I'm being really able to be involved in issues that have mattered to me for a very, very long time, and really actually possibly making a difference in the world. That's tremendously rewarding.
I dissected Gavin's statement that he read. I don't know if it was you who wrote it.
When he left the Proud Boys? No, I didn't write it.
And
if I'd been representing him then, a lot of things would have been done.
Okay, and one of the things that really struck me, and I've talked to him about this personally, is that it's these guys who, like, some girlfriend was selling merch for the Proud Boys on some Etsy site or something, and she's fired for this. And he's like, come after me. Like, not even I can handle it, but this guy is powerless and is stigmatized for life, and he's got a kid. Like, this is their mixed race, they have a kid, and now people are calling him a Nazi, and he has absolutely not even the slightest possibility of defending himself.
Well, all right. First of all, that's a bit of an overstatement. He does have platforms. He has indirect platforms. He's actually still on YouTube.
How do you mean Gavin? I mean the guy.
The guy. Okay.
Wait, Gavin's talking about this poor Proud Boy guy. He's just like, this guy's life is ruined and he can't do anything about it.
Tremendous. He feels as if, and this is not an attorney-client confidence. I'm sure he said the same thing to you. This is something he said to me as a friend. Actually, he's never said it. I just observed it. He feels a tremendous amount of responsibility.
Yeah.
He absolutely felt he was doing a good thing. Helping God, he had developed a sort of philosophy of, he's a bro, right? Guy, he's a hipster, which is a male.
He invented hipsters.
So this is a very male concept. He recognizes that male bonding and male busyness are things that have to be addressed, especially in a leisure society. It wasn't a problem, male bonding and male busyness, 100 years ago. For our ancestors in Eastern Europe, male bonding was either if you were privileged, you were in the yeshiva, and if you were 98% of the rest of guys, you were milking cows or schlepping water from a well. Like, you didn't have time to worry about being busy.
Maybe the banya. Maybe.
Maybe. That's already for the older guys.
Yeah.
So by the time you get to the to our world where people have time in their hands and it's not a matter of subsistence, you need to find a way for guys to keep busy, be productive, and focus on good things, and also to recognize that they're going to be guys. They're going to be guys in a guysy way.
Yeah.
And also one of the many topics that he's discussed, and it's always interesting watching him discuss it with guests on his show who don't see it that way, is that being a guy has been under severe attack over the last 5 to 10 years. So the Proud Boys was his idea of a way to do that, to address that. He knew that he had an audience, and he really labored to make sure that any aspect of racism, extremism, hate group type stuff would be absolutely off limits. And yet, nonetheless, despite those efforts, and despite the fact that his intentions were really idealistic, he never made any money from the Proud Boys, that's for sure. Okay. He's gotten all these guys in all kinds of trouble. Not he's gotten, but by virtue of being Proud Boys, guys who work in paint stores and selling stuff on the internet are now deplatformed by cowardly, anonymous internet scum.
I think it's far worse than merely being deplatformed. It's like the idea that you're some kind of crypto Nazi is just socially insane, and for these regular guys.
Well, look, for some people, it's more insane than for others.
Sure.
I mean, the number of times you and I have both been called Nazis on the internet.
I actually yell at people to stop when people who are fans of mine run in to correct them. I go, do not tell them I'm an immigrant. Do not tell them I went to yeshiva. Let them dig their own grave. Let them look stupid.
They do not care. They don't care. They don't care about the facts. They don't care.
Yeah, but the objective third party is going to care. The viewer is going to look at this and be like, all right, I don't know who this Malice guy is, but this is clearly ridiculous.
Yeah, I mean, and like you said, if my friends on the internet want to say, don't you know he's an Orthodox Jew? Don't you know his family was destroyed by the Holocaust? guys, because they've been following me, they know the
Sure,
story.
sure.
I'm not going to fight that anymore. I'm just blocking these people or ignoring them. But it's, it's an interesting legal question. Do we now say that the term of opprobrium Nazi? We're not even talking about neo-Nazi.
Right.
The Nazis lost the war. Right. That's over. Okay. Mengele escaped. He's dead now. There are no actual Nazis anymore. The National Socialist Party of Germany is defunct. Neo-Nazis, fine. Let's say that there are neo-Nazis. But the idea so do we say that is a term of opprobrium which constitutes defamation per se? It's like having a loathsome disease or a claim of, lack of chastity. Or do we say, something everybody says? Well, if that's something everybody says, I'd like to hear a judge say that too, because that means that when you say that such and such group is a bunch of Nazis, you're not acknowledge that you're not saying anything.
Right.
And that's not a basis to deplatform someone. So it's got to be one or the other.
I was at Charlottesville, and I talked to Gavin about it afterwards, and I was saying that they were Proud Boys at Charlottesville, and he could not interrupt me faster. He goes, no, there weren't. He goes, I told them ahead of time, if you go to Charlottesville, you are kicked out of the group, period.
It's a good thing you were in the group, because he would have kicked your ass.
Well, I wear Red Sherman, not Fred Perry, so I don't even have the uniform correctly. Okay. I mean, the problem with litigation is that it's so tedious and takes forever, right? So
it can.
Where are you guys in the case right now?
In that 60-day period,
okay,
during which they have time to either answer or seek to dismiss, or there are other possible defenses under Rule 12, but fundamentally, we're waiting for them to respond. Yes, it's a slow process. The wheels of justice do grind slowly. Some places faster than others.
What do you think of the whole situation with Laura Loomer? Are you following that one?
I am.
Are you representing her as well?
I am.
Oh, okay.
So there'll be news on that front soon.
Oh, I call her the Anne Frank of Twitter.
Well, I think it's enough to be the Laura Loomer of Twitter.
Well, there is no Laura Loomer of Twitter.
And that's the problem.
Right.
Listen, there's a lot to answer for with the way Laura has been treated. And people often get the impression.
Would you advise other clients to chain themselves to Twitter headquarters?
I wouldn't have advised her to do that either. But I will say this much. First of all, that the person who did advise it knows what the hell he's doing. Okay. And second, but is not a lawyer. Secondly, people do have the impression, if you represent Nazis, and I'm going to call anyone on the right a Nazi, you're a Nazi. And that's obviously asinine. The ACLU, of course, represented actual neo-Nazis in Skokie.
Very famously, yeah.
Maybe we're 5 or something, but I was already, a little bit more grown up. And I was revolted by it, coming from a Holocaust survivor family. Nonetheless, I got it. I understood it. They're not being Nazis. They're saying that there have to be standards that apply to everyone. ACLU is no longer dependable in that regard, unfortunately. Anti-Defamation League is no longer dependable in that regard, unfortunately. They've had a precious little to say about in the anti-Semitism debates of the last week or so. It's very disappointing. Not surprising, though.
Yeah.
I'm not Gavin. I don't adopt. I mean, I spent a lot of time with Gavin in the last couple of months. I haven't heard him say all that much that I disagree with, frankly. And as I said, I was on a show in the past.
Yeah.
But having said that, I don't adopt everything he's ever said on any show, any tweet he ever made. I do believe that he is, by the way, being punished for not following me on Twitter, and I think he understands that. Laura, I also knew previously. I don't agree with every single thing Laura ever tweeted, but that's point one. Point two is you don't even have to be to say I don't agree with everything Laura ever tweeted. You don't even have to like Laura. You don't even have to think that she's right about anything. But you've got to acknowledge that there's a problem with content-based censorship that is not really hate.
Yeah.
It's not really, and even if it's hate, I mean, look, the Supreme Court in the Slans case, and this is where it comes full circle for me. They said in response to the USPTO that said, we don't want hate speech to become registered as a trademark. And the Supreme Court said, as a matter of First Amendment jurisprudence, that's not private censorship. We have to say that so someone doesn't excerpt this and say what a schmuck Coleman is for not knowing the difference. in First Amendment, for what the government can or cannot censor, hate speech is a non-existent category. And my hope at that time was that people would read that opinion and say, if it's true regarding the First Amendment, maybe it should also be true on our campus.
Yeah.
Maybe it should also be true on our social. I was a little bit naive. That didn't happen at all. It had no effect on public debate whatsoever, that case. None.
Yeah, hate speech is just speech I hate.
No, exactly. So hate speech is still a category that is used in the social justice warrior crowd and the like. Prohibited, listen, you can have terms of use. You really ought to, if you're going to hide behind your terms of use, you really ought to apply them consistently. So I think Laura, even though she's a guerrilla warrior.
Oh yeah.
She's a street artist. When your platform is just yourself and you're relying on free services, which is, it's a dubious business model.
Sure.
But she was building a meaningful body of work and making a living from it and doing no one any harm. No one. Nonetheless, she was taken down by forces that do not have our interests, and I say our meaning America, our interests at heart. We got to start, there's got to be a solution to that.
All right, we have time for one last question. What has been your favorite part of the interview?
You didn't even tell me that I would get that question. I love talking about my work. So any opportunity I have to talk about my work, frankly, is welcome to me. And your questions are thoughtful and insightful. They're not cliched questions. And plus, how often do I get to speak to a yeshiva guy on social media?
You are welcome.